All right, looks like people are starting to come in here. We'll just go ahead and kick things off. Good morning, everyone. Thank you for joining us for the DAYL Coffee with the Probate Court. This is sponsored by the Elder Law Committee of the DAYL, and we are excited for today's program. Just to wake everyone up, we're going to start things off with a giveaway of a $10 Starbucks gift card, because this is the Coffee with the Court. And so what we're going to do is we're going to ask a question of those, and if you'll use the Q&A feature on Zoom to submit your answers, but we're going to ask the question. The first 3 people will get a Starbucks card, and the question is, what chapter of the Estates Code would I look in for questions about notice and citation generally? So if you want to submit a answer to that, just use the Q&A feature on Zoom and submit an answer to that. And I would also just say that this is CLE credit is available for today's Coffee with the Court for 1.5 hours of CLE credit. So thank you for all of those who are joining us today. Okay. So we've got an answer that's come in here. Let's see, anyone else? Okay, we've got another answer come in. We'll give this just a few more seconds. Okay. All right, so we've got a few answers that are submitted here. Chapter 51 is the correct answer. So those of you who answered chapter 51 for notice and citation generally, you'll get the first 3 will get a Starbucks gift card. Okay, so we have a fantastic lineup of speakers. We've got the Honorable Judge Brenda Thompson and Ryan Troby. What I'm going to do is I'm going to introduce each speaker, and they'll speak for approximately 30 to 45 minutes. And then we'll take questions at the end of each speaker if you've got questions for them. And what I'll ask is that you submit those through the Q&A function. And so our first speaker is going to be the Honorable Brenda Thompson. She is the presiding judge of the Dallas County Probate Court, and she's the presiding probate judge for all Dallas County probate courts. She earned a Bachelor of Science from the University of Maryland, a Master's of Arts from Boston University, and her Juris Doctorate from Georgetown University. Prior to the bench, she was in private practice, and Judge Thompson will be providing us today with practice pointers for young lawyers working with the probate courts and those who wish to practice in the probate courts, and any other tips that she wants to provide us with. You know, Judge Thompson had mentioned to me yesterday that she's been a part of this program for the last 5 years, and so we're very happy to have her be a part of this. She's always gives great advice for young lawyers and those who join this program, and so we're very honored and happy to have her here. And so I'll just hand it over to Judge Thompson to go ahead and take it from here.
Well, good morning. On this rainy morning, I'm delighted to see you. Even though I can't see you, you can see me. But I'm just very delighted to be here. I love teaching. I know I only have 30 or 45 minutes. I could teach all day. That's my first love. So you watch the time, tell me when I need to cut it off. And anytime you want to have a teacher, I'm available. I love it. Let me just not make any assumptions. I know that there are probably some people on the line who don't know very much about the probate courts. And I want to just say briefly that there are 3 statutory probate courts in Dallas County. Each of the courts have an associate judge. And finally, as of October 1st, each of the statutory probate courts will have a briefing attorney. And so if you see that your statutory probate judges are gleeful, that's why. Now, the court structure for all of our courts is that we have an administrative assistant. In our court, Olga Moreno is the administrative assistant, and Amanda Winberg is the docket coordinator. Now, I want to start with a topic that's near and dear to your heart. What is that? Money. Okay, I hope you're awake this morning. All right, so money, that means I'm going to talk about court appointments. Anybody who's not interested in money, go back to bed, okay? You'll need to go to bed. All right, we make a lot of attorney ad litem appointments in this court. We make attorney ad litem appointments more frequently than any other type of appointment. Most of you, if you practice in probate court before most of the statutory probate court judges, we'll start you off with an attorney ad litem appointment in the heirship area or in the guardianship area. Also, I'm going to talk about some other specialized areas in a moment, but I'll just go through the types of appointments. We do the attorney ad litem appointment, the guardian ad litem appointment, mediation, temporary guardian of the estate, temporary administrator, permanent guardian of the estate, dependent administrator, and receiver. Okay, now I could spend a lot of time talking about those various appointments, but I encourage you to look into what's required for those appointments. I just want to point out to you that for attorney ad litem appointments and guardian ad litem appointments, we are looking for people who have the requisite statutory training. Now, the attorney ad litem appointments, as I said, occur in the heirship and in the guardianship area. They also occur in areas like the sale of minors' property. They also occur in the area of emergency removals under Chapter 48 of the Human Resources Code. And we also make attorney ad litem appointments in long-term placements. So just check out, make some notes and check out those kinds of things. And so typically what I need from you, if you want to be on the attorney ad litem list or any appointment list, is for guardianships, you must present your certificate of training and you must keep it current. Now, we frequently have to look people up if you're not in Dallas County. If your certification doesn't show up in Dallas County, you need to let us know that you're certified and you're on the register in another county. Now, money, attorney fee guidelines are available in our office, as well as I believe they're still up on the Dallas Bar Association website. I have not checked recently. The website is really very difficult, very challenging to get through for most people. And I hope that they will improve it at some point. Now, another determinative factor in appointments is bonding. We are under a requirement that we bond on assets, not on fungible, on liquid assets. All right, so we need to know what your bonding capability is. And you find that out by calling a bonding company, and they'll have you they'll pull a credit report on you. They'll ask you some questions, and they'll tell you, well, you can be bonded up to $500,000 or up to $2 million, or we can't bond you at all. And that's a factor in determining appointments. Also, your experience obviously is a factor in determining appointments, and your geographic location and your language proficiency. We have a number of, sliding down in my chair, we have a number of foreign language cases coming through the probate courts. So we ask that if you have foreign language capability, that you identify yourself so that we can utilize your services. We have the ability to provide interpreters only on a very limited basis. So typically I will not appoint an English-speaking attorney to a case where the client and the client's family are all going to be foreign language speakers, because we don't have the budget for that. If you consult the attorney fee guidelines, you'll see that it tells you that we don't allow billing for contacts with the court staff. And also I need to tell you that if it is a case where you will file an affidavit of inability to pay so that the Dallas County Treasurer pays the bill, that fee scale is lower, okay? And we expect all attorneys to be good citizens. And so you may get one of those cases where you're providing reduced fee services. And we try to spread them around, but it's our responsibility to make access to justice available to all of people in our community. So we have cases where I need to have people who will do those cases and do them professionally. If you have questions about that, just let me know, or you call the office and we'll talk to you about your fees. We try to, we've recently, this is good news for you, we've recently raised the amount of the attorney ad litem deposit to $500. And that is going to be the typical payout on simple attorney ad litem appointments on heirships and guardianships. We always keep in mind whether or not we are being judicious, whether or not the attorney has used their time wisely. I don't pay for a lot of research. You have to do a lot of research. You probably don't need to take the appointment right now. Let me direct your attention to the probate local rules. It took us considerable effort to get some Dallas County Probate Court local rules. I worked on that project with former Judge Chris Wilmoth. It took a lot of effort, and we are proud of the fact that we now finally have those rules. And I encourage you to read them and to understand them. One of the things that I would point out about the local rules is we include a certificate of conference provision. And so you must confer with your opposing counsel on settings. And all orders that are going to be presented to the court need to be submitted to all of the counsel in a case. Now, let me move on. If you've never been to the Dallas County Probate Court's website, shame on you. We work really hard to put together a nice website, an informative website for you. I invite you to visit the Dallas County Probate website. We have many administrative orders there. We're in the process of changing out old orders, putting in new orders. I recommend that you consult that website periodically to see if there's new information there. Obviously, with the orders coming out of the Supreme Court regarding the pandemic, that's the place that we're putting up information. We're sharing the information through the Dallas County Probate section, but another place to find the information will be on our website. I know there's a burning question in your mind about, well, how much longer are you going to be at Renaissance Tower? And we have to pay those outrageous parking fees. Well, I'll tell you, your guess is probably as good as mine. Okay. We have been given a number of stories. Seeing is believing, and that's about all I can tell you. Okay. Now, let me talk about Probate Court 1 and the case management system that we use in Probate Court 1. I think that you know my reputation, that I try to keep cases moving, that we have worked very diligently to make certain that you have access to the court. If you have a contested case, in virtually every contested case that I know of, I always have an initial status conference. At that initial status conference, you'll get a trial setting. I'll give you a deadline for a scheduling order. I'll assign a mediator. I'll give you a mediation completion date. And I have a check-in feature. Every 90 days, I check in on contested cases because that helps the case to keep moving. You don't come and talk to me every 90 days just to visit. You come and talk to me every 90 days to tell me what you're doing to move your case along. And I require that we have that you set your pretrial conference, pretrial conference on a trial at least 10 days before trial. And at that point, all dispositive motions should be handled and ruled on. I'll say a word about mediation and the selection of mediators. I try to match mediators to the type of case that's being handled. And all mediation is not the same. There are some mediators who know how to ask the salient question. They know exactly what to ask in a particular situation because of their area of expertise. And so it's kind of like, I don't know if you remember the where's the beef kind of thing. Well, that's the kind of question that a mediator has to ask at a particular point in time. Well, how can you prove that? What can you do? Okay, so that's what I'm looking for when I'm selecting a mediator. Also, for example, in guardianship cases, I'm looking for a person who has a great sensitivity to the situation, a person who will ask the right kinds of questions, who will understand that when you're at mediation, this is the best time to discuss difficult issues with family members, such as end of life planning, visitation, religious preferences, all those kinds of things. And so I'm looking for, if it's a family law issue, I'm looking for a mediator who has a good grasp, a working knowledge of family law. Okay, if it's a paternity question in a probate case. And so I assign attorney ad litems, guardian ad litems, and all these other kinds of people based on my awareness of what their expertise is. I mean, no one wants a surprise, and you don't want a person who has no familiarity with the issues in your case, even though they may be a lawyer and maybe a long-time lawyer. And so I try to be sensitive to that in terms of the person that I select to mediate your case. Now, let me say that I've already, in the interest of full disclosure, told you that I love teaching. All right, so I also want to tell you that we have an open door policy. Okay, you're always welcome to come down to, well, you can't come to the courthouse. You're always welcome to ask a question. I don't want you walking around. It's better to ask than to not ask. And one of the reasons that I'm on a probate bench as opposed to a family law bench or a criminal law bench or some other kind of bench I practice in a lot of different areas is the people in the probate section are very collegial. They're very helpful. It's okay to say, I don't know. I say, I don't know. Okay. It's not possible for anybody to know everything there is to know about probate. Probate is a complicated area. It's a complicated area. It's a complicated area. Okay. It bleeds over into a lot of other areas. The only area in my entire practice that I've not utilized on the probate court was when I was a beginning lawyer. I started out my practice or my legal career at the Federal Trade Commission. I was an antitrust lawyer. And so I haven't had it to use that, but everything since. And I actually have to qualify that because I handled some federal deceptive trade practices cases, and I've had that issue come up in some of the cases. So not federal, but the state deceptive trade practices law. So I want to emphasize that you're always welcome. I can't, you can't ex parte me, but you can ask about court procedures. You can ask about how we like to have things done. Each statutory probate court is very different. What I told you about my case management system may not be the same in other courts in Dallas County. I can tell you that except for prove-ups on wills, we do prove-ups on wills Monday, Tuesday, and Thursday most of the time, okay? But if you have an emergency, we're available. We'll work with you, okay? And after that, all other kinds of cases is first come, first serve. I'm very interested in having, and being an open court, even in the pandemic. So you are welcome to, if you have an emergency, let us know. We'll try to figure out a way to work you in. No one should wait an unreasonable time to get to the courthouse. So let's move on. Probate is a very interesting area. When I was thinking about this presentation, I was thinking about all of the fascinating cases in the probate area. One of the things that we grapple with in the probate area is fraud, exploitation, and abuse of elders. And I don't know if you saw the news yesterday, but Doc Gallagher got 3 life sentences yesterday for defrauding people. He had a major Ponzi scheme that fleeced people out of at least $23 million. So he was convicted over in Fort Worth yesterday. Okay, if you want to read about something interesting going on, or the famous case of 4949 Swiss Avenue, that's a case, another example of exploitation. Who hasn't heard of Anna Nicole Smith? Okay, that's a famous case. It involved James Hartnett, the Hartnett firm. He represented one of the people in that case. There was Rusty Harden. And Anna Nicole Smith was, I think, 27 years old when she married J. Howard Marshall, and he was 89. And that lawsuit went on for years. In fact, it spawned a couple of very famous cases, the Marshall versus Marshall case, as well as the Stern versus Marshall case out of that. So, I mean, you just look around and probate is everywhere. And probate usually involves all of the wonderful things like money, sex, violence, crime. So you're never bored if you're working on probate matters. Also, recently, the issue of guardianship reform has been in the news. Our own Senator Ted Cruz and Senator Blumenthal from Pennsylvania held senatorial congressional hearings on toxic guardianships. And who was front and center? None other than Britney Spears. Okay, so that's an example of the kind of cases that you can get involved in. One of the most interesting cases that in my court was a case involving medical marijuana. And I had to make a decision as to whether or not I would appoint the dad in the case as a joint guardian of the person of the child. And you know that there have been a number of efforts in the state legislature to expand the use of medical marijuana. And at the time, the case had been, of course, reviewed by Child Protective Services, the DA's office. Everybody had looked at the situation, and all of a sudden it's in my court. And so, I apply the law and make a decision. Now, our decisions are reviewed not only in the Court of Appeals and the Supreme Court, but they also are reviewed in the Court of Public Opinion. So we are very sensitive to the fact that we are guardians of the trust of people. People trust us, and we expect everyone, including all the lawyers and all the people who come before us, to take seriously the opportunity to appear in court and the opportunity to represent people. Now, one of the cautions that I would say to you is don't do anything that's beyond your capability. If you have never read the disciplinary rules, please take a time to read them. I mentioned that cases are very complex. And if you find yourself in a situation where you feel like you're underwater or over your head, or however you want to characterize it, reach out for help. There are a lot of people in the probate bar who are very willing to help you. And if you don't know anybody, ask somebody. Ask the people who are in the probate section. Ask your colleagues. If you're a member of the Dallas Association of Young Lawyers, there are other probate lawyers. Ask the people who are in the regular probate section. Ask me. I'll find you a mentor, okay? And they will report on how cooperative you are too. So, but I encourage you to do that. 4 years ago, there was a very famous or sensational or interesting, I don't know what the right descriptor is, case in Probate Court 1. It was a case involving J.P. Morgan Chase. It involved teams of lawyers, and it resulted in an $8 billion verdict. That $8 billion verdict was the 9th largest verdict in the United States, not just in Texas, in the United States. And so that was lawyering at the highest level and brilliant lawyering. And so, but for lawyers who are not at that level, it was an opportunity to observe how it's done. And so I encourage you, once we ever get back into the courtroom, to come and watch some of the hearings, to come and watch some of the trials, because you will see how it's done. And I always encourage my interns to make contact with good lawyers. Ask them, can I sit in on, I'll sit on the back row, I'll carry the briefcase so I can watch and see how it's done. That's how you learn. So now let me shift. I think I have only, what, am I out of time? I can't hear you. You're muted. I don't know how much time.
Apologies. You've got a few more minutes, Judge.
Okay. Let me just give you a quick pointer, a few pointers. One of the things that I see that I want to caution you about is make sure your record's complete. Make sure that you get everything into the record that you need to have a complete record. Use a script, use a checklist, use bullets, use whatever helps you to be organized. Just don't come down to the probate court and try to wing it, okay? I once had a hearing, both lawyers showed up with not even a yellow pad, okay? And you know how far that went, okay? They were not that good. So make sure that you get, that all of your elements are proven, that your exhibits are admitted. Make sure that you properly use judicial notice. Make a logical presentation. Point out the key points on a CME if you're doing a guardianship case. Please do not confess judgment. Don't say, Your Honor, take him to jail. That, Your Honor, put him under guardianship. Your Honor, he doesn't deserve to win. Don't confess judgment on your client. do your job, okay? I've seen that a few times. I also want to tell you, there are a lot of service problems that come up and will matters, probate matters, where you're trying to admit a will to probate. One of the biggest issues is names. The names have to be consistent throughout. So all of you all know about, also known as. I once had a case where the guy used 7 names. Okay, I had to list all of the names. All of the names need to be consistent. They were known in the will. They used one name, but also they describe people in the will using nicknames. Make sure that your notices are consistent with the document that you're presenting to the court. In airships, anticipate what the questions are going to be about the history, the family history. Okay, watch situations where you're trying to do airship within an airship. Make certain that you account for everything or every question that could conceivably come up with respect to airship issues, lineage issues, and try to anticipate what kind of questions I will have. You know, typically I'm always going to ask about notice. I'm always going to ask about notice. Okay, if you want the power of sale, you have to plead for power of sale. I can't just say, okay, it's okay, you can do it. All right. Make certain that your client has their documents. If we're doing it on Zoom, make sure that your client has the documents in front of them. Don't wait until the hearing to print the documents out. I've had people show up at the hearing. Oh, I thought the court was going to provide the documents. Or if you're from East Texas, I've had East Texas lawyers come in and say, why do we have to have any documents? I've got live witnesses. Well, that's a problem. So the last thing I want to say is you're doing a good thing. To invest in yourself and to try to get information from people who know something about probate. I believe all education is good education. It's something that you are doing to help yourself be a professional and to be a contributor. Remember, we're in a helping profession. We're here to help people. And that's my attitude. I'm a servant of the people. I'm trying to do the best that I can for you and the people that you are trying to serve. Thank you.
Thank you so much, Judge. We really appreciate hearing from you. I love hearing all of the great insights that you have. And, it seems like there's a lot of opportunity to have some future presentations, because I'd love to hear more of your thoughts on some of the cases that you've seen over the years. And I did want to ask a question. We've got a question from the audience about is there anything in the clerk's office that's being done to help ensure that filings are being accepted and notice is posted in a timely manner? I know that's a question that's popular among people right now. Generally, can you mention anything? And Ryan has mentioned something in the comments, but is there anything you want to add to that?
I'd like to say that the judges have met with Mr. Warren. I believe that Mr. Warren is working very hard to resolve the problems in his office. I think that he has brought in extra clerks, but of course they're not probate clerks. So there's a delta between the time that they arrive and the time that they're actually able to be of assistance. Probate service and notice and citation in the probate area is different from the civil area. But I think that he is aware of the difficulty. He's had some staff transition. I think 3 valuable members of his staff have gone other places. And I think that also we're having a lot of systemic problems with our document management program. They've switched from a program that worked to a new one. And there are just a lot of glitches in the program. We are trying to do as much in the way of workarounds as possible, but it's just a process. We are meeting with the provider. I think it's in a couple of weeks, but we are aware of the service problems, and I promise you, we are doing everything on the court side to push the clerk side, and the clerk side is doing everything they can to get up to speed. But we're aware of the problem. We're aware that, I mean, it was not as efficient as it needed to be before we had this problem. And in the pandemic, it's obviously gotten worse. And so I'm very sympathetic. I know it makes it very challenging to practice when you don't, get efficient service, but we're hopeful that it'll change soon.
Perfect. Thank you. Thank you so much, Judge. And we're so thankful for you to be a part of this. You're such a familiar face with the DAYL, and we're so grateful that you're so approachable and so willing to help younger lawyers to join this practice area and to grow in their understanding. And so it is time for another Starbucks card giveaway to refresh everyone's coffee. So we do want to give away 3 Starbucks cards to the first 3 people who can tell me what chapter of the Estates Code I would look into for questions related to venue. So if you can answer that question, the first 3 people, just to wake people up. All right. Okay, so we've got some answers coming in here. Perfect. Okay, so it is chapter 33. So if you answered 33, then you are correct. Perfect. Okay, so and if you have questions, please continue to submit those. I'll collect those as we go along and make sure those get asked of our speakers. Our next speaker is Ryan Troby. Ryan is the staff attorney for the Dallas County Probate Court 2 as of May of this year. Prior to that, Ryan was in practice with Pike & Associates. Ryan is a graduate of SMU Dedman School of Law, and he obtained his bachelor's degree from Baylor University. Ryan is going to be providing us with his unique perspective of working inside the courts as a staff attorney after coming from private practice. And he might also be able to share with us how that transition was made possible, what that may look like for those of you who may be interested in doing that yourself someday, and just some unique insights that he may have that he's learned by doing so. And he's also provided 2 handouts. Those are in the chat feature if you want to take a look at those. But I'll go ahead and hand it over to Ryan if you want to take it from here.
Thanks, Aubrey. I appreciate it. And thanks. It's good to, again, I can't see anybody besides the participants, but it's good it'll be better when we see each other in person. We're talking about the probate section, and probate is a great area to be in. It is a growth area, obviously demographically, and with the DFW area having more people move here every year, it seems. There's a reason that the number of new cases in our probate courts have increased by about 25% this year. So you picked an area, and as Judge Thompson said, one in which the probate bar is very collegial, and it's a great place to work. I'm going to break my talk into 2 different sections. The first is talking broadly about a roadmap for lawyers who are interested in getting into the probate space, and what does that look like? What should you be doing? And second, to talk about my transition to the probate court what that looks like from a procedure, some of the things that I see, and maybe some tips and tricks to help you get a successful hearing when you're in probate court 2 at least. So as Aubrey said, I've got a couple handouts so you can refer to those. The first one is kind of a roadmap for lawyers who are wanting to get into the probate space. And broadly, I would say visibility matters and reputation matters. So getting in front of the probate courts is going to be helpful to advancing your career in the probate space. And how do you do that? First of all, you get on the ad litem lists. The ad litem list, there's one for each court, as Judge mentioned. There's that certification that you're going to want to have. But there's kind of a progression when it comes to these appointments. At first, you'll likely get these guardianship and routine heirship appointments. And from there, you may continue on and ultimately get appointed to some administrations or even receivership work. So that is a great way to get in front of the court, to meet other lawyers. I will mention Judge King's from Tarrant County. His ad litem manual is still a gold standard in terms of a reference tool for ad litem work. 2, come and visit the courts. Well, you can't, it's harder to do that these days, but I still think it's valuable to make yourself familiar to court staff. Court 2 is in the office, so if you're ever down to the 22nd floor, come by and see us. We also have our hearings, Court 2 does, on YouTube. So you can subscribe, it's got its own YouTube channel. You can watch the hearings as they're going on. And that is a helpful way to understand kind of, if you've never had a particular case before, you can look at the docket, see when one is scheduled and come watch and see how it's done. Third, I'd like to say, study the estates code. The probate practice is a very statutory practice. And your first instinct when it comes to how you prepare for your application for your case is to look at the estates code. There are so many times where I am calling an attorney and telling them, you know, you need to do X, Y, and Z, and they mention cases where we've always done it this way, we've always done it this way, and you gotta base it on the statute. You need to constantly refer back to the statute. Also, there's the version, I know the O'Connor's version of the estates code has great tables in the front of it that not only conversion tables from the old probate code, but also tables for dependent administrations or guardianships that really step-by-step break down the process and will make sure that you've got all your steps. They've also got the heirship chart, which is super helpful as a reference. And then fourth, I would say get involved with your local probate bar. The DIYL section, you're here, so that's a great start. Also, the DBA has a probate section. That's a good way to get involved. I know Jack Fan puts on a study group. There are a lot of Facebook or listservs where you can get involved with local estate planning and probate attorneys. Also, the Dallas Volunteer Attorney Program has a pro bono group that has sort of, you can take pro bono cases, but then there's an overarching probate mentor who will get assigned to you. So you can get involved, get in front of the courts, and make a connection to another lawyer who could serve as a mentor. I think mentorship is very important, and luckily we've got a really great bar for that. So those are broadly the tips that I would give if you're looking to grow a probate practice. So I started, back when I was in law school, I clerked at Probate Court 3. Then I hung up my own shingle for a few years and then practiced probate privately for 7 or 8 years before joining the courts. So I've seen things from both sides. I practiced in front of the courts, and then now I've joined Court 2 as their staff attorney. And I want to transition and talk a little bit more about my role here, about some Court 2 specific things, but then ways in which you can prepare and have a successful result for your hearing. So my role as the staff attorney here is to broadly review cases prior to them being heard. The aspirational goal is to get 2 or 3 weeks out where I'm reviewing all hearings that occur except for the routine wills that are heard by our Associate Judge Lincoln Monroe. All other cases I'm reviewing, and what I'm looking for is I've got checklists. I'm looking for the boxes to be checked, the statutory boxes, and with the increased volume, that I've got a process done that I look through. I check every case, and they start to stand out when there are issues. Then the goal is that I can contact the attorneys in advance of that hearing, well enough in advance where we can right the ship and potentially save the hearing date and get a successful result. Broadly speaking, and there's a quote from Leo Tolstoy's novel, Anna Karenina, that I want to share with you. Happy families are all alike. Every unhappy family is unhappy in its own way. And while we see our share of happy families and unhappy families, that's also true, I think, of probate cases. Happy probate cases tend to look alike, but there are a myriad of ways that a case can get thrown off kilter. Generally speaking, here are some things that Court 2 is looking for. The reasons why a hearing that you would have would be fatal, would have to be kicked or rescheduled, or wouldn't have a successful result. Service is a big one. Service is what confers jurisdiction on the court to hear the matter. And there are a lot of ways that can have wrinkles in it which aren't addressed. For example, copies of a will have additional service requirements. Probating a will is a muniment title over 4 years. There are additional service requirements. If you are doing a determination of heirship, there are service requirements that need to be done. And so I have a checklist that I go through to make sure those things have been accomplished. Second, amending your pleadings. So generally speaking, Probate Court 2 has a standard that we're looking for. When you're originally seeking relief, let's say you're probating a will. Well, probating a will generally has posted notice that runs and returns. Let's say you amend your application because the original applicant can't do it anymore. You got to go to the first alternate executor. Well, you're seeking different relief. It's a different applicant. That's got to have new posted notice run and return. Often I see folks who will amend their pleadings and not redo that citation or that posted notice. And that's an issue that can affect hearings. Another big one is the certificate of service on heirship applications. So 202.057 of the Estates Code has this summary of service in an heirship proceeding that says, this is everybody who's entitled to service and this is how they've been served. And I probably, it'd be high to say 50%, probably 40% of the heirships I review don't have that. So I always call and tell them to fix that. Some other common issues that cause cases to be kicked. For heirships, the certificate of service is a big one. Wrong application of intestacy law. So in terms of who is getting what, we often see issues related to, let's say there's a surviving spouse and kids that aren't of the marriage, how the community property is dealt with when there's a sole surviving spouse, but that's the only heir. There's still separate real property that can go to the decedent's family, their parents and siblings. So those are two areas I would defer to that chart and look at it every time when you are putting together your application to determine heirship. And to represent those in fractions instead of percentages. A lot of times we'll see 33.333 repeating, but if you literally applied that, there'd probably be a 0.01% that is hung off. So we prefer fractions for that. We get a lot of copies of wills. Wills that the attorneys swear up and down are originals, but when we look at them, they've got stippling on the signatures or some other indicia that they're copies, and we've got to scramble to fix that. I have had 3 of those in the last week where they were set for hearing, and we've had to address that. In 2 of those cases, they ended up finding the original will and hustling down here, and we were able to preserve the hearings. So one element to that just to kind of back up and speak more broadly, these are some niche issues, but because we have the volume where we've got tons of cases that we're hearing every week, a sort of niche issue like that, when I was in private practice, I probably ran into that once or twice a year, but I'm now seeing it weekly due to the fact that we're processing and reviewing such a volume of cases. So that has given me additional familiarity, just because you see the same stuff over and over again, stuff that for a private practicing attorney, you may only run into on a handful of occasions. So to reiterate what Judge Thompson has stated, call us if you've got an issue, or if you've got a unique situation that you're not quite sure how to handle. Give us a call, particularly in an uncontested case. And what I wanted to do, I will ultimately, I'll leave it in the chat, my direct dial phone number and email address, where if you've got any Court 2 specific questions, to let me know. I provided, the second handout was a 10 tips to get paperwork right for letters testamentary. So that's in probating wills, some 10 key points. It's obviously not comprehensive, but it handles a lot of the things that we see over and over again when it comes to probating wills. To talk a little bit about some Court 2 stuff, we have transitioned partially to where we're maintaining a virtual docket for most of the day, but we are also doing some in-person hearings as well. So our website, the Court 2 website, has a link to our virtual and in-person policies and procedures for how we want our hearings to be conducted. And that's a great resource when you're preparing for those hearings. If you have a preference for one or the other, just let our docket coordinator know when you're calling, and we'll make sure that you fall on one or the other. It's interesting, the way it's shaken out now, there's a bit more people to choosing the virtual. So if you want to have a quicker hearing, you can do it in person, and oftentimes we can set you earlier than that. I wanted to talk about a few Court 2 specific policies, might be the right word, positions, things that you should be thinking about in Court 2 that are nuances to our court. First, if you are wanting to establish an heirship that includes a informal marriage, a common law marriage, our court wants a separate declaratory judgment on that issue. It can be heard concurrently with the underlying heirship. It can be heard at the same time. We want it broken out as a separate declaratory judgment. 2, regarding copies of a will and muniments over 4 years. These are 2 instances where even though you're dealing with a will, we have service requirements that the heirs at law are notified of the proceeding. And in those 2 circumstances, our court is always going to appoint an attorney ad litem. So have that expectation going in. For copies of a will, you've got a burden, a presumption of revocation you've got to overcome. For muniments over 4 years, you've got a default that you've got to overcome. And in both those instances, the attorney ad litem is there to hold you to your burden on that point. Before I go on, I see, does Judge Thompson have her hand up? I want to make sure that that's, no? Okay, great. I just want to make sure if you had a question. I already talked about this a little bit, but amendments versus supplements to pleadings. So if you're changing the relief that you're looking for, if you are adding heirs to your heirship application, if you're requiring that the distributees are now going to agree to a independent administration, something like that, you're going to want to amend your application and redo whatever the notice is that was initially required. Repost notice. If it's an heirship, you're going to republish both to the Daily Commercial Record and to the OCA website. Let's say it's a smaller change, though, where you're not really modifying what you're seeking. You're not changing what the ultimate relief is that you're looking for. You're just kind of putting some meat on the bones of your argument. Let's say you've got an heirship and you have a predeceased heir or a sibling who died and didn't leave any kids. So it doesn't affect the underlying heirship fractions, but it's just more information the court should have. But we'd like to see that done in a supplement, which is a document that, think of it kind of like a codicil to a will. It is just a 1 or 2 paragraph thing that changes or adds that additional information. But if it doesn't change the heirship fractions, if it doesn't change things that the public should be notified about, should be done in a supplement, and that would not require redoing that notice. Let's see here. One other issue, well, related to that, let's say that you have initially done a determination of heirship. You've got all these folks who are entitled to notice. In most airships, you don't actually give them notice. You instead pass the hat and collect these waivers that are saying, I waive notice to this, to the heirs, and I consent to an independent administration in a lot of cases. Let's say after you've done that, you've gotten the waivers in, they're part of the record. Then you turn around and you've got to amend. We find somebody else. Suddenly the heirship fractions change. Well, the heirs agreed and consented to the original application. They didn't agree to potentially to this change that's occurred in the amendment. So you may have to pass the hat again and get new waivers. The thing that we're looking for, the magic language on those waivers, is that an heir has consented to the citation of the application to determine heirship and any supplements and amendments thereto. If we've got that language in there, then the waivers are quote unquote durable and would survive to any later amended applications. Similarly, you would want to redo your affidavit, your certificate of service for the heirship if you amend, to make sure that with this new iteration that you've gotten everybody served the right way. That's another thing that comes up quite a lot. A few nuances that I've run into a fair amount, again, because we've got such volume, we see these things on a regular basis that a lot of folks don't. Creating independent administrations. Obviously, in an heirship, you have to get all of the heirs to agree to do that. Similarly, there are 2 will types of cases where, let's say that the will didn't provide for independent administration, or we run out of executors and have to do letters of independent administration with will annexed. This is in the 400s, 401.002 for the wills and 401.003. Well, the statute says that all the distributees have to agree on the independent administration. But let's say that the will says, I leave everything to my spouse, and if they don't survive me, to my children. But the will doesn't say who the kids are. Then we've got an issue with identifying those distributees. We've got them, it kind of circles back to the theme broadly. The court wants to make sure that there's not someone who should have been included in the process who comes back later and says, well, I wasn't given notice of this, I didn't consent to this, and throws a wrench in the works. So a lot of these issues are making sure that the court has clarity about who is supposed to participate in this process and how they have been given notice. And the clearer you can make that, the better. Other issues are foreign wills. Our court likes to see attached as exhibits what the foreign law is that makes a will self-proved or makes a will valid for wills that are executed in a foreign country or state. And then I mentioned the bit about informal marriages. So those were the main points that I wanted to get across. Broadly, it was what the court is looking for, what I'm looking for when I'm reviewing cases. I've got a checklist that I go through. My goal is to get back in front of the attorneys to preserve that hearing date if it can be salvaged, and to at least have clarity about what needs to be done to get the case in statutory compliance. Because I am reviewing a higher volume of cases than I did in private practice, and I think this is true of all court staff, we see things on a more routine basis than you probably do. So if you've got a unique situation that you haven't dealt with before, particularly in uncontested cases, give us a call and we can talk through that. We want to be a resource there. And then 3, I just wanted to point to a few of the Court 2 specific positions and things so that there isn't any confusion on that, and talk through some resources. Look through the local rules, look through the code, and look at Court 2's website has those virtual hearing policies and procedures. We've got one question, let's see here, from Kara Featherstone. Are there certain matters that can be heard by Judge Monroe as his docket might be less busy versus Judge Warren? Which matters are required to be heard by Judge Warren? That's a great question. So it kind of depends, which isn't a great answer. If a case has previously been heard by Judge Warren, it will continue to be heard by Judge Warren. So if there was a previous substantive hearing on the case, Judge Monroe isn't going to hear later hearings if there are multiple ones on the case. If it is a contested case, and obviously there's a qualitative difference between a lot of routine cases that are still quote unquote contested because there's an ad litem, and true contested cases. Contested cases are on Judge Warren's docket. And then if there are cases involving more complicated points of law, one example would be an airship that had a declaratory judgment component to establish an informal marriage. That would go onto Judge Warren's docket. But Judge Monroe hears routine will prove-ups, he hears airships, he will hear temporary guardianships and administrations. Typically the contested document, the contested type cases that have been previously heard by Judge Warren are going to be heard in the main court. Well, that was everything I really wanted to talk about. I wanted to make sure that there's additional time for additional questions or comments. Or I'm not sure, Aubrey, if you've got any questions.
Thank you, Ryan. Let me see here if we've got any questions. I'm not seeing any, so we may not have any questions, but thank you for the presentation. You know, one thing that I like that you hit on was probating a copy of a will, because I can't tell you how many times I get asked questions by clients, can they probate a copy of a will? And sometimes it's because that's the only thing they can find. And sometimes it's because they don't want to spend the time and effort to try to find an original. And so knowing that there's additional procedures involved with that, and I see in your handout that you discuss some of those additional procedures, and you had mentioned those in your presentation. So I think that's very helpful for all of us. And so I want to thank you, Ryan, and you're a familiar face with the DAYL Elder Law Committee as well. You've certainly been a part of it for many years, and so I love that you're also very reachable for people, and I'm sure that people that are filing cases in probate court too, they may be getting a call from you at some point to discuss the case, and they could reach out to you if they have questions as well. So thank you, Ryan, and thank you, Judge Thompson, both for your time today. And, and thank you for those who had responded to the Starbucks questions. I've got here William Biggers, Melinda Hartnett, Matthew Rittmeyer, Patrick Krim, and Elaine Ross twice. Elaine won twice, so she's going to be getting 2 gift cards. But thank you all for joining us today, and we look forward to hosting this again next year with the DAYL Elder Law Committee. And also be on the lookout. We're going to do a happy hour with the Elder Law Committee and those who want to be a part of it before the end of this year to get together for that. So anyways, I hope all of you stay dry today and have a wonderful rest of your day. And thank you all again, and take care.